Hi, episode 2, and this is about documents that can catch self-managing owners out now and will definitely be an issue after the 1st of May. This is our calm countdown to the 1st of May. Most problems in renting don't start with bad tenants, they start with paperwork that quietly isn't right. If you manage your own rental property, this episode is especially important for you. But let me start by reassuring you, this isn't about scaring you. It's not about telling you you've failed. And it's certainly not about creating unnecessary work. It's about understanding how documentation has become the backbone of renting and why, from the 1st of May, it matters more than ever. At Maxine Lester, when owners run into difficulty, it's almost never because the property is unsafe or the owner is unreasonable. It's because when a decision is questioned, the paperwork doesn't quite stand up. Now, a recent example, a landlord who asked us to end a tenancy as they wanted to sell the property. And like all situations where we carry out anything for a property that we haven't managed, we carry out a documentation audit. In this case, we found a problem with a gas certificate. Now, it had been issued, but there was no proof, and that it actually had been served to the residents. And also, it didn't have a postcode on. 2 issues that would definitely have the notice thrown out had the resident gone to court. So we're not talking about someone breaking the law. A gas certificate was carried out and all was fine until the landlord wanted to end the tenancy. And these are the silly little things that catch people out by surprise. Most self-managing owners tell us the same things when we talk to them. I gave them the gas certificate. The deposit was definitely protected. They've had an EPC for years, and in many cases that's true. But going forward, the law won't ask whether something was done. It will ask how, when, and whether you can prove it. So let's break it down. Over the years, documentation in renting has evolved layer by layer. What was acceptable 5, 10 or even 15 years ago may no longer be sufficient, even though it felt perfectly reasonable at the time. And this is where long-standing owners are often most exposed, because documents tend to be reused from previous tenancies. They're stored across emails, laptops and filing cabinets. They're sent informally or verbally referenced, or even inherited when a resident stays long-term. And none of that feels risky until scrutiny appears. So let's look at some key areas, starting with gas safety certificates. It's not just about having one, it's about whether it was valid on the exact day the resident moved in, and whether it was served correctly, and whether you can evidence that the service, and also does it have a postcode on it, which was a new one to us. We regularly see certificates that exist but were issued after the tenancy started. To an owner, that feels minor. It's a timing issue. Legally, it can be a major problem. Energy performance certificates, EPCs, again, most owners have one. But is it the correct version? Was it served at the right time? Does it meet current standards? An EPC quietly expiring or being overlooked doesn't cause an issue day to day, but it can limit your options later. And this is really what we're talking about. The Renter's Rights Guide is one of the biggest traps for self-managing owners because it changes, and it changes more often than people realise. The How to Rent Guide was introduced by the Deregulation Act back in 2015, and it's required to be given to all new tenancies and all existing tenancies which are renewed. It's also necessary to update it when an existing tenancy has basically become periodic and on any renewal. So, for example, one change in May 2017 took out the reference to the London Mayor's rental standard. That was the only change. But that change made a lot of Section 21 notices defective because the landlord had served the wrong notice. So serving the How to Rent Guide isn't enough. It must be the correct version, valid at the time of service and provable. Over the last couple of health check calls that I've held with landlords, I've emailed it years ago, I printed one off, I think it was attached, but think, unfortunately, doesn't count. Deposits, still one of the most common and costly areas where things go wrong. Going back to 2012, after the 6th of April, you had to serve prescribed information and protect the deposit within a limited time in a nominated scheme. So if your tenancy started before 2012, you had 14 days to sort things out. Most owners protected the deposit in a custodial or an insured scheme, but protection alone isn't the full requirement. The prescribed information must be correct, complete, served within the legal time frame, and provable. Missed signatures, outdated wording or late service will undermine your position years later, even if the resident has been perfectly happy. And this is where people feel frustrated because they think, well, I did the right thing. Morally, probably they did, but legally, morality doesn't carry weight. Evidence does. So let's talk about why this matters more than anything from the 1st of May. The direction of travel in the sector is very clear. We're moving away from informal resolution and towards structured oversight. Local authorities, tribunals, advisors are increasingly focused on process, consistency and audit trails. And it doesn't mean they're looking to punish good owners, but it does mean the margin for error is shrinking. And that's why we say documentation isn't about bureaucracy, it's about your protection. When everything's correct and provable, rent reviews are smoother, complaints are easier to resolve, tenancy changes are less stressful, and decisions are far easier to defend. When documentation is patchy, everything comes a bit harder. And if you're managing the property yourself, this is where you need to concentrate your time on now. You're not just managing a property and having a relaxed chats with your residents. You're managing legislative updates, version changes, service rules, record keeping, and future-proofing decisions that you haven't need to make yet that can carry a lot of weight in the future, especially if you've only got 1 or 2 properties. When we take over a property, as I mentioned, we carry out a full documentation audit, and that's what you're going to have to do. And I want to be very clear here. You're not a reckless owner. What we found is that documents were right once, but aren't now. Gaps caused by long tenancies or assumptions based on previous rules. And that's not failure, that's just time passing. The reassuring part is this. Once documentation is reviewed, corrected, organised, a huge amount of anxiety disappears. Owners stop worrying about the what if. They stop second-guessing decisions. They stop lying awake wondering whether something was missed so they can't do something. And that confidence is going to be invaluable. Next week, we're going to build on this by looking at tenancy agreements, because even perfect documents can't compensate for an agreement that no longer reflects how tenancies work today. So if you're watching this and thinking, I'm not sure everything is quite as tight as it should be, that awareness alone puts you ahead of the curve. And if you're thinking, I just don't have time or inclination to manage this level of detail, that's exactly why professional support exists for you. Why don't you subscribe to get next week's issue? Because by subscribing, we're going to look at tenancy agreements and why so many self-managing owners are unknowingly relying on outdated wording. The aim here is to give you calm, clear, one step at a time information. So just pop over to our YouTube channel, Maxine Lester TV, because we've got lots of hints like this as to the best way to handle increases and, more importantly, the best way to do them. Remember, compliance will be changing from the 1st of May, so just stay informed and get the confidence to be able to do things correctly. And if you don't want the responsibility of keeping up with every change, well, again, that's what I said, that's exactly where expert support makes sense. So don't forget to subscribe, and we'll start with the most common mistakes that we see in documentation that looks fine but actually isn't. See you next week. Deposit was definitely protected. They've had an EPC for years, and in many cases that's true. But going forward, the law won't ask whether something was done. It will ask how, when, and whether you can prove it. So let's break it down. Over the years, documentation in renting has evolved layer by layer. What was acceptable 5, 10 or even 15 years ago may no longer be sufficient, even though it felt perfectly reasonable at the time. And this is where long-standing owners are often most exposed, because documents tend to be reused from previous tenancies. They're stored across emails, laptops and filing cabinets. They're sent informally or verbally referenced, or even inherited when a resident stays long-term. And none of that feels risky until scrutiny appears. So let's look at some key areas.